AB 256, witnesses in support. Witnesses in opposition. Finance.
Department of Finance is opposed to this bill because it could increase the state prison population, which, as I keep saying, impacts the state's ability to comply with the federal court's order to reduce prison overcrowding to 137.5% of design capacity. California's institutions are currently below that cap, and we are being as creative as possible to make sure that we can stay below that cap. We note this measure could also impose new costs and workload on counties, which creates additional fiscal pressure on the local criminal justice system.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we're going to move this item to suspense file. Moving on to AB 696, witnesses in support. Witnesses in opposition. Finance.
The Department of Finance is opposed to this bill because it could substantially increase the workload for the courts, resulting in significant additional general fund costs. We note that the fiscal impact to the state and counties will vary to the extent that defendants request a determination of probable cause, which could result in significant time and costs for the courts. However, to the degree that the trial is avoided as cases are dismissed due to lack of probable cause, there's potential for cost savings. We know that the Judicial Council has published a letter saying that the courts, requiring this new process for the courts would result in approximately $25 million in costs. And that's based on the most recent data of approximately 900,000 misdemeanors filed in California, of which 90% represent out-of-custody individuals. While we agree that there would be significant workload, we are concerned about the methodology that the courts use to determine costs and that it doesn't take into account defendants that plead guilty. Thank you.
Comments or questions from committee? Seeing and hearing none, without objection, we'll move this item to suspense.
To suspense.
Apologize. Senator Nielsen.
On the point that you raised here, this does set up a separate track. It would appear to me, and probable cause is a very easy standard to accomplish. And so that's going to dictate, are we not going to be able to see some very serious offenders get a little easier deal with this bill because of the probable cause hearing and the determination. So they want to dispose of these cases early. But a probable cause hearing is a lot different than a full court proceeding. Please.
So the probable cause hearing request would be made at the time of arraignment. So they're sort of already in court doing the arraignment. And so the Judicial Council estimates about 3 additional minutes of court time. We think it's even less than that because if you're pleading guilty at arraignment, you wouldn't be requesting that probable cause hearing. But it does potentially allow you to request a separate hearing, which has to happen between then and the start of trial. So you're right in that there is the possibility that people wouldn't reach the probable cause threshold. But theoretically, if they wouldn't reach that probable cause threshold, then a trial would also find them not guilty if there was not even enough probable cause for an arrest.
It would seem, though, at least it's dilatory in the conduct of the justice system, is it not? Because you're throwing another little step in there, this probable cause step.
Yes, and it's a step that exists for misdemeanor defendants that remain in custody now. But if the idea being that we don't want people to lose their liberty without that sort of trial. And I think that the argument that folks would make is that there's some amount of liberty loss if you're out of custody because you have this sort of misdemeanor hanging over your head. But I think your point is absolutely true, that it does allow sort of another bite at the apple to be released.
It's a second bite at the probable cause apple, because at the time of the arrest of the individual, the arresting officer had probable cause for whatever the behavior was. So you're now giving us a second bite at probable cause, it would seem like to me. Okay.
I think that's fair.
Thank you.
Thank you. Without objection, we're going to move this item to the suspense file. See Assemblor Williams, please come forward. Soon to be a father. The floor is yours. Members, this is item AB 969. Please proceed.
Thank you, Mr. Chair, Senators. AB 969 would expand the authorization of a community college district to deny enrollment or permit conditional enrollment if an applicant has violated this district's policy on sexual assault, domestic violence, and dating violence. The bill would also authorize a community college district to require student applicants to disclose whether they have been previously expelled from a community college for a violation of their district-adopted policies concerning campus sexual assault. Members, community colleges in some parts of the state are separated only by a couple BART stops or by 10 miles, and so being expelled from one community college does not guarantee safety to the students in the adjacent community colleges. A hearing by a local community college governing board would be required for an applicant who has made prior violations, providing an opportunity for the board to assess whether the admittance of the applicant would impact campus safety. Projections for hearing costs are about $3,000 to $5,000 per hearing. However, community college districts are already supposed to do this according to law, both to meet their Title IX requirements and current state law. And so while it should factor into your decision-making the costs, I also would argue that the bill should not be dinged for something that the community colleges are already supposed to be doing. The bill ensures that community college districts have the tools necessary to protect students, employees, and the public in cases of the most egregious violations of sexual assault policies.
Thank you. Witnesses in support.
Good morning, Mr. Chair and members. Sally Espinoza from the Attorney General's Office in support of the bill.
Thank you.
Good morning, Chair and members of the committee. Michael McGee with California Community College's Chancellor's Office. We are in support of this measure.
Thank you. Any additional witnesses in support? Witnesses in opposition? Finance.
We don't anticipate any state-level costs because while they're granted new authority, all of the activities would be permissive.
Thank you. Comments or questions from committee?
I have a question. It's actually policy, but very quickly. We're always concerned about due process on situations like this. What sort of protections are in there to ensure there's due process given to the student who is, I guess, being reviewed the second time in terms of whether the allegation was in fact true and substantiated with evidence?
Well, each campus is required to go through certain procedures and to be able in their adjudication outcomes to say that the preponderance of evidence indicates that this person is culpable. And of course, they are not being deprived of liberty. And so there is not required to meet the same evidentiary standard in cases where you are deprived of liberty. And I would argue this is why we need to pursue this route. In cases of sexual assault statistically in our society, there is, depending on who you ask, between close to 0% or single-digit percentage that you'll be found accountable for the crime. And that is because in many of these instances it is hard to prove beyond a reasonable doubt. The people usually know each other, and so it is necessary for us to use the campus adjudication procedure to accomplish some measure of justice and accountability that the criminal justice system simply is unequipped to do.
Yeah. Well, I'm going to support it today, but it would be helpful if we had a little more information on the actual process that the boards go through as they're looking at a record of evidence that this person, in fact, is a problem to allow on the campus.
If we can just
provide that.
If we can just provide that information to our Vice Chair, we would greatly appreciate that.
We will do so.
Thank you.
Thank you. There is a motion by Senator Leyva. Secretary, please call the roll.
The motion is due pass to the Senate floor. Laura?
Aye.
Laura, aye. Bates?
Aye.
Bates, aye. Bell? Aye. Bell, aye. Hill? Aye. Hill, aye. Leyva? Aye. Leyva, aye. Mendoza? Nielsen?
Aye.
Nielsen, aye.
We're going to keep that item open to allow our absent members to add on. Thank you, Mr. Williams.
Thank you, Senators.
Members, we're going to continue to work the file as quickly as we can, understanding we're, oh, I didn't see. Okay, Senator Bro, please come forward.
Oh, Bill is here.
Members, this is item 1277, correct? Please proceed.
Good morning, Mr. Chairman and members. The amount of the levy that the Taxpayers' Rights Advocate is authorized to return has not been increased since 1996. AB 1277 relieves taxpayers facing severe financial hardship by allowing the Taxpayer Rights Advocate to return a larger portion of the levy. The bill increases the amount from $1,500 to $2,300 and allows adjustment for future inflation. The bill passed the Assembly floor on consent and the Senate Government and Finance Committee with unanimous bipartisan support. The costs are minimal, estimated at $1,300 annually, according to committee analysis. I respectfully ask for your aye vote. With me is Michelle Peelsticker with the Board of Equalization.
Thank you. Witnesses in support.
Good morning. Michelle Peelsticker on behalf of the State Board of Equalization in support of the bill and also the bill's sponsor. Although the return authority is not used often, when it is used, it makes a real difference in whether someone is able to stay in their home, see a doctor, have enough food for the month. It is only in these types of extreme circumstances that the BOE Taxpayer Rights Advocates even considers returning money on a levy, which still does not relieve the taxpayer of their liability. I have with me Mr. Todd Gilman, our taxpayer rights advocate, to provide some examples of when this authority has been used and why increasing the cap would be meaningful for taxpayers who need it.
Thank you.
Good morning, members. Todd Gilman, taxpayers rights advocate with the State Board of Equalization. This is for those individuals that have demonstrated they are suffering a hardship that has now become a health and welfare issue, whether it's a cancer illness or whether or not someone's been in a car accident. This amount of money means the world to these individuals. And it's never enough. $1,500 does not cover the costs that we're talking about that these individuals have had this experience with. So that's why it's so important that you support this bill. In fact, it may have been maybe a few of your constituents that I've helped out over the years that have contacted me that have needed this support.
Thank you. Additional witnesses in support. Witnesses in opposition. Finance.
We're neutral on this bill because the amount of lost revenue is small compared to the potential benefit to a small number of taxpayers in extreme hardship, as noted by representatives from the Board of Equalization. And as the author noted, the amount that can be returned to taxpayers has not been increased since 1996. We're looking at potential revenue losses of around $4,600.
Thank you. I have a couple of questions on this item and to kind of explain why I'm not supporting this bill today. You know, I know the committee analysis indicates that the bill has minimal fiscal impact. Nonetheless, because I think an analysis also notes, and maybe you can explain to me, the demonstrated need for this bill I don't think exists. Both the minimum wage and the maximum of tax and fee rates are not automatically indexed for inflation under current law. That's one of the reasons, I mean, the major reason why I'm not supporting it. The other is, what has been the largest amount that the TRA has returned to a taxpayer?
Every single time it's been $1,500 and they've asked for more.
Every single time?
That's correct.
That's not consistent with our analysis. I think our analysis was, and maybe we, has been that the TRA has used this authority once and has never returned the maximum amount permitted under current law. So we're trying to figure out why we need the extension of this cap. So you're saying that we have given this maximum amount?
The max.
Okay. So now we're being told otherwise. This is interesting. You know, I just want to double check, Senator Barral, if you would allow me to do further research and maybe we could bring this bill for vote only next week.
Absolutely, Mr. Chairman.
Thank you. I just want to make sure that we're clear, because my understanding is that we've never reimbursed people up to the $1,500, and so I just want to make sure before we invest more of these resources that we actually need to increase the rate. So I would appreciate that we can bring that back as vote only, without due respect to you, without any. Thank you. I appreciate that. Thank you. Members, we're going to continue to work the file. That's AB 235 by Assemblymember Frazier. Witnesses in support? Witnesses in opposition? Finance.
We're neutral on this bill because it aims to reduce teenage car accidents by strengthening the state's provisional driver's license requirements. However, we are concerned that this bill will continue to contribute to current challenges facing the motor vehicle account, which we project to be insolvent in 2017-18.
Thank you. Comments or questions from committee? Seeing none, without objection, we're going to move this item to a suspense file. Moving on to Senator Gordon's items. That's AB 379. Witnesses in support. Witnesses in opposition. Finance.
We don't have a position, but note that the bill could create a reimbursable state mandate in the tens of thousands of dollars of Prop 98 general fund annually by requiring school districts to incorporate complaints of violations into the existing UCP.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we're going to move this item to the suspense file. Moving on to Assembly Lowe's item, AB 570, oh, sorry, did we miss the court? I'm sorry, I'm getting ahead of myself. We're still on Assembly Gordon's item, that's AB 1465. Witnesses in support, witnesses in opposition. Finance.
No file.
No file. Comments or questions from committee? Seeing and hearing none, without objection, we'll move this item to the suspense file. Moving on to Assemblywoman Lopez's item, AB 1207. Witnesses in support. Witnesses in opposition. Finance.
The Department of Finance is opposed to this bill because DSS already provides extensive resources for mandated reporters, including free information and pamphlets, contact information, forms, guidance, and contacts for reporting, and free online training for all required mandated reporters with a certification upon completion.
Thank you. Comments or questions from committee? Senator Bell.
I think when we look at the fiscal impact of these kind of bills regarding mandated reporting, it's very important to look at it from a litigation avoidance expense fiscally. So lawsuits, et cetera, can be avoided by better training.
Exactly. Thank you, Senator Bell. Without objection, we're going to move this item to the suspense file. Moving on to Assembly Low, AB 578. Witnesses in support. Witnesses in opposition. Finance.
The Department of Industrial Relations anticipates it would need $291,000 from the Occupational Safety and Health Fund for one position of a counsel position and one legal secretary position to process additional workload for variance hearings.
Thank you. Comments or questions from committee? Without objection, we're going to move this item to the suspense file. Moving on to AB 652, Cooley. Witnesses in support. Witnesses in opposition. Finance.
We're neutral on this bill as we see the potential for long-term savings from the avoidance of future maintenance if the highway is actually relinquished.
Thank you. Comments or questions from the committee? Seeing none, without objection, we're going to move this item to the suspense file. Moving on to Senator Manchin's items, AB 702. Witnesses in support. Witnesses in opposition. Finance.
The Department of Finance opposes this bill because it increased general fund costs by about $4.9 million annually, and those costs are not included in the administration's latest fiscal plan.
Thank you. Comments or questions from committee? Seeing and hearing none. Senator Bell.
Providing temporary shelter to people without housing does save money in the long run and the short term in terms of avoidance of other health, emergency, urgent care costs. So I think in looking at the broader aspects of providing shelter, there is a cost savings.
Thank you, Senator Bell. Any other questions or comments from committee? Without objection, we're going to move this item to the suspense file. Moving on to AB 861, witnesses in support, witnesses in opposition. Finance.
This bill results in minor absorbable costs for DHCS to apply for participation in the demonstration program should the initial planning grant be awarded to California. To the extent that they are successful in competing for participation, the bill has the potential to reduce non-federal share of costs for specified county mental health services, resulting in county savings.
Thank you. Comments or questions from committee? Seeing and hearing none, we will move this item to a suspense file. Moving on to AB 833 by Assemblymember Bonta. Witnesses in support. Feel free to sit closer if you like to.
Nicole Wurtelman on behalf of the Alameda County Board of Supervisors in support. This measure would simply allow Alameda County to utilize their subsidized child care allocation more flexibly and serve more children.
Thank you. Witnesses in opposition. Finance.
This bill doesn't create additional statewide costs, as the authority provided under the individualized plan extends only to state and federal funds that have already been received by the county. However, because the pilot program is intended to reduce unused child care subsidies returned to the state by the county, it could result in ongoing Prop 98 and non-Prop 98 general fund cost pressures to the extent that there's less funding available for redistribution to child care providers in other counties, which is what we do now.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we're going to move this item to suspense file. Moving on to AB 858, Assemblymember Wood. Witnesses in support. Witnesses in opposition. Finance.
This bill would result in potentially significant general fund costs in the Medi-Cal program for additional utilization and reimbursement for clinic visits for marriage and family therapist services. This bill also results in administrative costs to the Department of Healthcare Services, as clinics would be required to apply for rate adjustments to reflect their increased costs from providing marriage and family services.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we will move this item to the suspense file. Moving on to Assemblymember Quirk. AB 909. Witnesses in support. Witnesses in opposition. Finance.
The Department of Finance is opposed to this bill because by requiring law enforcement agencies to submit data to the DOJ, this bill could result in a reimbursable state mandate with significant general fund costs.
Thank you. Comments or questions from committee? Seeing none, without objection, we'll move this item to the suspense file. AB 1013. Witnesses in support. Witnesses in opposition. Finance.
The Energy Commission estimates this bill would require 3 new positions and approximately $972,000 from the Energy Resources Program account on an ongoing basis. Included in these costs are $500,000 in annual contracting costs.
Thank you. Comments or questions from the committee? Seeing none, Secretary. If I'm running the floor now. Without objection, we'll move this item to the suspense file. Moving on, members, to AB 976, Senator Steinnorth. Witnesses in support. Witnesses in opposition. Finance.
Department of Finance opposes this bill due to its negative impact on state revenues. Further, because most taxpayers will not benefit from this tax deduction, it's unclear that the bill will actually increase pet adoption rates. FTB estimates total general fund revenue losses of $100,000 annually.
Comments or questions from committee? Seeing none, without objection, we will move this item to the suspense file. Moving on to AB 1126, Assemblymember Rendon. Witnesses in support. Witnesses in opposition. Finance.
We believe that this bill would create a state reimbursable mandate by requiring local educational agencies to update their internet websites with the information specified in the bill. We think that that will be minor overall, but we're not sure.
Thank you. Comments or questions from committee? Seeing none, without objection, we will move this item to the suspense file. Moving on to AB 1185, Assemblymember Ridley Thomas. Witnesses in support. Witnesses in opposition.
Mr. Chairman, members, Richard Markson for the Western Electrical Contractors, Plumbing, Heating, Cooling Contractors, Air Conditioning Trade Association, and Associated Builders and Contractors of San Diego, opposed to the policy.
Thank you. Additional witnesses in opposition.
Thank you, Mr. Chairman. Senators, Julianne Broyles here on behalf of Associated Builders and Contractors of California. We are opposed on the policy. We think it does reduce opportunities for merit shop contractors and would ask for your no vote.
Thank you. Is the light getting better?
I broke my back.
Oh, that was right.
But yes, thank you, sir. Thank you for asking.
Mr. Chair, Member Cesar Diaz, on behalf of State Building and Construction Trades Council, sorry for speaking out of order. We're in support of this legislation. Thank you.
Thank you. I figured. Finance.
This bill requires the LAO to submit an interim and final report to the fiscal and policy committees of the legislature on the use of the best value procurement method. The LAO estimates administrative costs of $150,000.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we will move this item to the suspense file. We are moving to Assemblymember Hernandez's items. Oh, he is not waived. Okay, we're going to move to close the roll on the items we have pending. We are waiting for Assemblymember Hernandez to come to the committee. We are going to begin lifting the calls, beginning with AB 605, Assemblymember Gatto. Secretary, please call the roll.
The motion is due pass to the Senate floor. Bates? Bell? Bell, aye. Nielsen? Nielsen, aye.
6-0, that item is out. Moving on to AB 332 by Senator Calderon. Secretary, please call the roll.
The motion is due pass as amended to the Senate floor. Bates? Bell? Bell, aye. Nielsen?
5-0, that item is out. Moving on to AB 531, Senator O'Donnell. Secretary, please call the roll.
The motion is due pass to the Senate floor. Bell? Bell, aye. Nielsen?
6-0, that item is out. Moving on to AB 559, Assemblywoman Lopez. Secretary, please call the... Oh, apologize for that. That is, we're going to move back to AB 566 by Senator O'Donnell. Secretary, please call the roll.
The motion is due pass to the Senate floor. Bell? Bell, aye. Nielsen? No. Nielsen, no.
5-2, that item is, that item passes. AB 559, Assemblywoman Lopez. Secretary, please call the roll.
The motion is due pass to the Senate floor. Hill? Aye. Hill, aye.
5-2, this item is out. Moving on to AB 969, Assemblymember Williams. Secretary, please call the roll.
The motion is due pass to the Senate floor. Mendoza? Aye. Mendoza, aye.
7-0, this item is out. Moving on to AB 1171, Assemblymember Linder. Secretary, please call the roll.
The motion is due pass to the Senate floor. Bell? Bell, aye. Mendoza? Mendoza, aye.
7-0, that item passes. Moving on to file item AB 353 by Assemblymember Patterson. Secretary, please call the roll.
The motion is due pass to the Senate floor. Bates? Aye. Bates, aye. Hill? Aye. Hill, aye.
7-0, that item is out. We, members, in order for us to allow us to go back to the floor for session, we're going to put over AB 1508 and AB 1509 by Assemblyman Roger Hernandez. So this concludes our appropriations hearing for today. Thank you.